Okay, so welcome everybody to our final masterclass for the year. It's been a great semester and year of talks. I hope those of you who've been to multiple talks have enjoyed them, and we'll have lots more next year where that came from. But we have a fantastic. Anyone who saw Abigail speaking at the Fish seminar back in, when was that?
February,
let's say February.
something.
Yeah, talking about copyright and AI, will know that there's lots of really interesting things to say about this topic. So Abigail is Recas is a lecturer. Recas lecturer in law and innovation, School of Law at the University of Galway, and a US attorney. So she's a copyright law and policy scholar with strong views about accessibility, deeply interested in the preservation and access to cultural heritage, including digital assets. So today she's going to talk about specifically around the issues around how digital technology is transforming our relationship to culture and copyright. So,
Hi guys. So I have to give you a caveat that I am going to be talking about copyright and AI, and I am going to hopefully leave you with more questions than answers, because this area is chaos. And a lot of the chaos has occurred because the development of these tools sort of happened without reference to copyright law. And now we are in a position where most of us are sort of like, I don't know what's going to play out. And that actually gives us a wonderful opportunity. And the point of this, or what I hope to get out of this, because I want something out of this masterclass too, is to ask you guys some questions and see what you think. Because we are in a moment of inflection, we are in a moment of change, and where we go into the future is up in the air. So if I can move through these slides, our agenda, I'm going to introduce you to me, which has already sort of happened, but you know, I made a slide, so I have to do it. I'm going to introduce you to copyright law, and we are going to start in the long ago past to bring us up to the modern day. And there are methods to my madness. So if you're sitting there and saying, why is she talking to me about the Stationers Act of 16, blah, 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 there's a reason, I promise. Just bear with me. Then I'm going to talk about copyright and AI specifically as it relates to the problems with inputs and the problems with outputs, including looking at the various litigations that are ongoing. And at the end, I'm going to ask you a couple of questions. And they're going to relate to who do we protect and why do we protect them? What new forms of authorship or creativity are enabled by generative AI? And I have a couple of use cases, one good, one scary. And what do you want to do? What would you like to see happen moving forward? So, as I said, I made a slide and it has hats on it. So as I said, I have to do it. I wear many hats. I am a lawyer. I am also someone who has a background in the arts. Long ago and far away, I was going to be a performer. I went to college for it and everything, moved out to Los Angeles and discovered, boy, oh boy, am I not interested in that life. And so I moved back to Boston and got a degree in history, and then I got a degree in law, and then I came here and got a PhD in law. So I've sort of taken a left turn, but not really, because it's still the exact same skill set. I stand in front of a room full of people and wave my arms around and try and convince them to believe me. Literally the exact same thing. So I am a researcher. I am particularly interested in copyright law and AI, as it might be evidenced by the fact that I'm here talking to you about copyright law and AI. I am also really interested in the preservation and archiving of video games. I was at the Fish Games Summit on Friday, sort of ducking in and out of that. And I'm also really interested in access to justice for people working in the arts, thinking about how we can enable people working in the arts to be better advocates for their own legal rights. And lastly, but not leastly, I am a teacher. I don't use the term lecture because I teach in a lot of different contexts and I care really deeply about it and communicating complex things in simple ways. And so these are the hats that I wear. And now we are moving, I told you we were going to go way back in time. We're going to talk about the Stationers Company. So for a really long time, printing was governed by a monopoly granted to the printers, the publishers. And they were responsible for censoring and controlling printed material. They were given a monopoly in return for services to the state where they censored what was published. Now, hopefully you hear censor and you think, but free speech, because that's what eventually did away with the Stationers Act and the Printing Act. So in 1695, Parliament, under pressure from various people in the UK, allowed the Printing Act to lapse, and it created a moment of chaos in the publishing world. Because at this point, when we were talking about intellectual property, we were mostly talking about copyright and written words, printed books moving through physical space. And so we had publishers setting up in Scotland and in England, and they were publishing the same works, and the ones in Scotland were being sold for slightly less than the ones in England, and the publishers were very upset. And so they began to advocate for a new act that would give them back their monopoly, that would give them the right to exclude others. And that didn't work because of the free speech thing. And so this sort of push for publishers' monopoly went on and on and on until they ran into a novel idea. And that novel idea was authorship and the notion of protecting authors. And so we see in 1710 the Statute of Anne, which in its preamble says, whereas printers, booksellers, and other persons have of late frequently taken the liberty of printing, reprinting, and publishing, or causing to be printed, reprinted, and published, books and other writings, without the consent of the authors or proprietors of such books and writings, to their very great detriment, and often to the ruin of them and their families. For preventing, therefore, such practices in the future, and for the encouragement of learned men to compose and write useful books. This is our first modern Copyright Act, and you might notice where the power vests is actually in the authors. So why did I start telling you about the publishers? Well, because they had the right to then license to the publishers. So we went from the owner of a physical copy of the book being the person who had control over that book to this notion of authorship. And there's a lot of scholarship over this sort of romantic ideal of authorship. But from that point forward, the rhetoric of copyright has focused on the author creator as the bearer of rights. And we see this going into the United States Constitution in what's known as the Progress Clause, to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this notion of this bargain, we are going to protect in return for an incentive to create. So you publish, we the public benefit, we give you a monopoly for a limited term. Now, the term limited is stretched beyond all reasonable meaning at this point, in my opinion. We are now at life plus 70 years. Initially, we were talking about 14 years renewable. That's not the point of this lecture. We're going to put that aside. So that is the economic common law right of copyright, this bargain where we protect in return for the creation of works, to incentivize the creation of works. This is not the only copyright model out there. The other copyright model comes from a notion of natural rights. And we see this sort of discussed as being really Lockean. God has given man the earth in common. You mix your labor with what you've been granted in common, and you have a right to what you then produce. And it's sort of tied to your personhood. Civil law countries adopt this notion of sort of personal rights in copyright. And so we see strong protection for what's known as moral rights. So one of the big problems, and this is going to be a problem that rears its head again towards the end of this lecture, is that copyright is territorial, which means that it extends to the boundaries of a country and no further. So copyright in the US is not copyright in Ireland. Copyright in Ireland isn't copyright in France. This was really okay when we were talking about tangible physical things moving through tangible physical space. But with the rise of digitization and the internet, we had sort of notional copies moving through notional space. And that made everything a lot more challenging because borders became a lot more squishy. Because I can access US copyright protections here in Ireland. And so which law is going about moral rights? Because the US doesn't have them. And when we are talking about copyright exceptions. Because while the sort of broad strokes of copyright do roughly map around the world, the exceptions where we don't protect doesn't. So we've made attempts over the years to harmonize copyright. In the EU, we have a series of directives. Most recent one is the Copyright in the Digital Single Market Directive. Controversial, but now mostly implemented, few holdouts. And in that, we see the sort of mandatory nature of exceptions and limitations, including two relating to text and data mining. But this harmonization is very political. This harmonization is very difficult. And while there's been attempts to sort of harmonize within Europe, that ignores where I'm from, because we don't like to do anything anyone tells us to do. So I said broadly, these things are harmonized in some ways. And one of the ways is what can be protected. So we're talking about books, poetry, software, paintings, music, dance compositions that are written down, phonograms, that is sound recordings, photographs, films. Non-authorial databases are an odd one that's a little bit different here than it is in the US. But if there is sufficient creativity in arranging a database, we're generally happy to protect it. Broadcasts, performances. We will protect these things and you will get some rights. And that includes the right to prohibit or permit reproduction of the work, so making copies, distribution of the work, public performances of the work, broadcasting or communicating the work to the public, and the creation of derivative works. And there's two here that are really important when we're talking about generative AI. The first one is reproduction. Because when we are training a generative AI model, we make copies, period. The training of an AI requires making copies. Whether those copies are then destroyed, whether those copies persist in the AI model, depends on the type of AI model you're talking about. But the training of an AI requires making copies. And the other one is the creation of derivative works. Because all of these copyright protected works that went into creating that AI are now essential components of what comes out. And so the argument has been made that everything generative or generated by a generative AI is in fact a derivative work of all of the training data that went into making it. which is it's a little problematic when we're thinking about who owns what when the Gen AI spits something out. And moral rights are also relevant here. So these are sort of the non-economic rights of a creator. And they include the right to patrimony, the right to be named as an author, and also the right to prohibit people from interfering or modifying your work without your consent. And again, this is problematic when we think about what a Gen AI model training does, because it is taking apart a work that is protected by copyright. And my classic example here is the films of John Huston. And this illustrates the difference in the US and in Europe. So in the United States, there was a decision made by Turner Classic Movies to colorize the films of John Huston, including The Treasure of the Sierra Madre, which is the film that you see stills from here with Humphrey Bogart. In the US, they were allowed to do this over the objections of John Huston himself and Angelica Houston. In France, they were prohibited from doing so. So territoriality is actually really important here, because what America may allow, because we have a purely economic style copyright, may not fly over here in Europe. But then we have the problem of the internet. So territoriality is a challenge. Which brings me to exceptions. So I don't know if anyone read the article in the Irish Times about the New York Times versus OpenAI case, but in it, they're talking about fair use. And I find this is a little bit of a challenging point because fair use doesn't exist here. There's fair dealing in this country, but fair dealing is not fair use. So fair use is a US exception to copyright. It basically means that if we find there is fair use, the copyright holder cannot prohibit a secondary use of their work. We have a lot of interesting case law about that, and we're going to come back to it. But it's a 4-factor balancing test that looks at the character of the new use. So what are we doing with it? The nature of the underlying work, how close to the heart of copyright is it? The amount that's taken for the new use, and the effect on the market of the original. And it's a case-by-case balancing test that courts are expected to conduct. Has been a fairly liberal doctrine that allowed for a lot of transformative and new uses that were at least recognizable from the works that they were taken from. In the EU, we have fair dealing. And in Ireland, it allows for the copying or using of the work for the purposes of criticism, review, news reporting, research, or private study. That is a very restrictive right. That is not a 4-factor balancing test, and it is a very narrow exception. So what would be allowable under fair use is not necessarily going to work under fair dealing. And this is one of the things that copyright scholars sort of spend a lot of time saying to people, that fair use doesn't apply anywhere outside the United States. Because, well, we have a pretty good PR machine when it comes to US cultural export. And so fair use gets talked about a lot around the world. And so when we're thinking about whether or not generative AI infringes copyright under fair use, we actually maybe have a stronger defense than we do definitely than we do under fair dealing. So when we're thinking about whether or not the training of generative AI infringes copyright, it's really going to depend where you're standing when you're making that judgment call. And that's sort of a As I mentioned, we do have a text and data mining exception here. These are found in the CDSMD in Articles 3 and 4. Article 3 allows research organizations and cultural heritage institutions to carry out, for the purposes of scientific research, text and data mining, but they can only do it on works to which they have lawful access. Whether or not they have lawful access depends on whether they've licensed or whether it falls into a category of an exception. Article 4 looks at whether or not, so you have the ability to text and data mine works that you have lawful access to for the purposes of anything, really. It's not defined. However, it contains a limitation on this exception, which says that rights holders have the ability to opt out. So if they include some opt-out provision in a machine-readable means, then they may not be text and data mined. There's some questions that come up because of this. Mainly, the CDSMD is fairly new. So a lot of the content that is available on the internet on which these generative AI models were trained was up there before this opt-out provision came into force. These models are already trained. So do we sort of presume that they're okay and that going forward, everyone should include a machine readable tag saying, please do not scrape this data when it's already been scraped? It's a little bit of closing the barn door after the horse has already escaped. So I want to move on now to AI, and I just want to address a couple of misconceptions here. The first one is that AI is smart. We are not talking about Cylons here. We are not talking about C-3PO. We are talking about what is essentially a probability generator. It looks for the next most likely thing. And that's true of diffusion models, and it's true of large language models. We are using probability to determine whether or not this is the next most likely thing, or this is what this image should look like. It is not independently generating anything. It is an algorithm. So when we talk about AI, it's almost a misnomer. And a colleague of mine in the law school, Dr. Ronan Kennedy, says it's a marketing term. It's a marketing term that has been used really, really effectively because people talk about this as if it is a Cylon. They talk about it learning, thinking, and that is part of the hype here because generative AI is not new. The first art generator was in 1972, and it was an art generator known as Aaron. So, and I'm blanking on this man's name, Cohen is his last name. He's been training a computer to make art, and his art hangs in galleries and museums around the world. And the name of the art generator is Aaron. And over the course of 30 years, he created an art generator that made really great art. And he trained it on his own art. And he refers to it not as an expert machine, but as an expert's machine, because the skill involved in using it and creating it is monumental. So when we are talking about generative AI in the arts, particularly generative AI and copyright, we are not actually in anything that is truly new. What's changed is the usability of the systems. Everything has gotten easier for us to access, easier for us to use. but it's not actually all that new. And the last thing, it's already being used pretty extensively in industries. For instance, in the film Elemental, they used AI to make her flame look flame-like. Throughout the course of Pixar's history, they have been experimenting with using AI to do lighting, to give weight to their characters moving through animated space. And this is actually something to bear in mind when I get to talking about the protectability of outputs. Because while this seems like it's a new debate, really it's just become a loud debate. We have been using these tools for a lot longer than it would seem. So we've got some issues when it comes to generative AI. And these issues include input. So the reason the volume of input matters in a discussion of copyright is the number of copyright protected items that are scraped. So GPT-3 was trained on approximately 45 terabytes of data. GPT-4, a petabyte. So when we're thinking about copyright licensing, when we're thinking about how do we make a system that is fair, there was a study published in 2020 that basically said the more data you have, the better the model will be. And research has borne that out. The bigger the training data, the better the AI model, the better the outputs. So OpenAI's large language model is based on 3 primary training sources. These are information that is publicly available on the internet. That one, so this is actually coming from OpenAI. Publicly available on the internet does not mean licensed, does not mean scraped with permission. It literally means you can access it on the internet with your eyes, not that you have rights over it. Information that they do license from third parties, and information that you and I and everyone who interacts with them. How many people have used ChatGPT here? So you guys help train that model. Every interaction with it is part of its training data. Everything you give it is part of its training data. Every time you put an email and say, change the tone of this email, that email is now in that training data. Just throwing it out there. Now, ChatGPT has estimated that by 2026, there will be no longer enough data on the internet to continue to train generative AI models. They will have scraped the entire internet by 2026. Even if we allow them to keep going, scraping copyright protected materials, they will run out in 2026. And they propose that they will move to synthetic data. And the CEO of OpenAI said, it should be fine. Synthetic data is data that is generated by a generative AI model and then fed back into the generative AI model to help train it. It should be fine. It gives me the hand flaps, I'm not gonna lie. So in a written submission to the House of Lords Communication and Digital Select Committee, they said, because copyright today covers virtually every sort of human expression, including blog posts, photographs, forum posts, scraps of software code, and government documents, it would be impossible to train today's leading AI models without using copyright materials. Limiting training data to public domain books and drawing created more than a century ago might yield an interesting experiment, but would not provide AI systems that meet the needs of today's citizens. The AI Act, recently agreed upon, does include some language about copyright law, including an obligation for AI companies to put in place policies that respect EU copyright law, including through drafting or through state-of-the-art technologies where applicable, to respect those opt-out provisions that the CDSMD allows for in Article 4. And it includes an obligation to draw up and make public a sufficiently detailed summary of the content used for training the AI model. So I have a couple questions here that I just want to sort of float to the room. One is, what should we be doing about all of those works that already have been trained upon? Do we care? Or is the horse well and truly out of the barn and there's just not much to do there? And the second one is in relation to this second piece. A sufficiently detailed summary of the content used for training the model. What does this mean in the context of a petabyte of data? Is it possible? What do you guys think about this?
What is the AI office?
Where am I? Oh,
The second paragraph.
that's going to be a EU body that's going to give us a template for how to do this.
Unless we force the companies to put everything in public domain. So that every output from them, because we have no way to stop, or because they're privatized, we can't see within how they've trained them. So
Well, they're going to have to publish what went into training them. So that's what that says. It's like all of the copyright protected material that went into the training of this must be published, must be made available to the public.
I mean, if it's a breach of copyright law and you can identify your work in there, you should have the right to have it withdrawn. And if that means blazing the whole data set, so be it, because they're the ones that broke the law in the first place. But I kind of find it hilarious that this AI Act, an obligation to put in place a policy to respect union copyright law. We're putting a law in place to tell somebody to respect a law that already exists.
Yep.
Like this is sort of symptomatic of the problem here, is that this huge amount of flexibility we seem to be granting these companies within the laws that we already have in place.
Absolutely. And this is one of the sort of criticisms of what we're doing around copyright and AI. Basically, they ignored copyright when training these. They have ignored the law. Now, whether or not they may be in the United States and taking advantage of fair use when training these things, that's a question. And that is what my next slide is going to handle. But they have ignored copyright in training these large language models. And they knew they were ignoring copyright. And so a lot of the debate around generative AI and copyright is, well, can copyright handle generative AI? Not, well, should we be prosecuting these companies for violating the law? It's sort of taken for granted that we want this technology. And we want this technology in this form. And that is something I want you to, that uncertainty is something I want you to hold on to. So we have a lot of copyright cases that have been filed since 2022, 17-ish. I say ish because a couple of them have been consolidated. One of them has been dismissed with leave to bring it again. But these cases are all about copyright infringement. Whether or not training generative AI infringed copyright. And what's really interesting to me and sort of peculiar, all but one of these is in the United States. There doesn't seem to be the same drive for litigation here in Europe, and I'm not sure why that is. But I want to focus on a couple of them. One of them is the New York Times versus OpenAI and Microsoft. And I also want to focus on the Getty Images case. So the New York Times case, the reason I want to talk about it is because it's one of the ones that I see as having the most likelihood of success, because many of these cases are small authors, individuals, bringing claims saying you infringed my copyright. They're going to be limited by resources. They're going to be limited by time. But New York Times, they got money. They have good lawyers. And they are alleging that Microsoft and OpenAI used their works to create artificial intelligence products that compete with the New York Times. They are alleging that they were built by copying and using millions of the Times copyright protected news articles, that Microsoft's Bing chat was free riding on the Times's investment in its journalism to build substitutive products without permission or payment, and that their Gen AI tools can generate output that recites Times content verbatim or closely summarizes it and mimics its expressive style. So that's the Times complaint. The OpenAI has responded in a blog post that basically says that they were in negotiations with OpenAI and that the Times walked away from the table, that they want to collaborate with news organizations, that even if they did use the New York Times content, it was fair use, but the Times has the right to opt out. Again, this is sort of horses out of the barn, let's close the barn doors behavior. There is something known as regurgitation, where the generative AI will spit out its training data verbatim. This does happen, but it's a rare thing. And that the New York Times is not telling the full story. They're relying heavily on the Google Books case, where a US court found that scanning books to create a text mineable database was sufficiently transformative to be a fair use. That the mass digitization of books by Google was an appropriate way for them to make books accessible for persons with disabilities. And because they weren't displaying the full book, merely snippets, sufficiently transformative that it was fair use. And that does seem like it's going to be a really strong precedent. However, the Supreme Court threw a spanner in the works last year with a case called Warhol versus Goldsmith. And in Warhol versus Goldsmith, they basically said, well, if this can be substituted for the original work, it's not fair use. So what they are likely to do in the context of generative AI is sort of, I don't know. We are in a moment of uncertainty. And it really matters. I know I'm telling you about US law, and partially I'm telling you about US law because this is where most of these litigations are happening. There is a sister case for the Getty Images happening in the UK as well. But the reason it really matters is in the US, we have something known as statutory damages. basically, you have an option. If your work has been copied or your copyrights have been violated, you can get the actual damages, that is the profits that this person made, plus the damage to your own work. Or you can elect to receive statutory damages per act of infringement. Which means every time that generative AI model runs, if it was trained on your work, you're going to get a payout. And those statutory acts of statutory damages per act of infringement can be $750 per act of infringement, or more than $30,000 if the infringement is found to be willful. It can even get up to more than 150 or to 150,000. So one estimate for the damages in the Getty Images case, this is a case that's around a diffusion model AI creating visual art. They estimate that those damages can be between 5,412,000 and nearly $1.1 trillion. That is an industry killer. In Doe versus GitHub, the plaintiffs estimate that statutory damages for defendants' direct violations will exceed $9 trillion. So what the US courts do in these cases really is going to matter. If they find it is fair use, what does that mean for us here in Europe? If we have them training over in the US, does that mean that we're not allowed to use generative AI models that aren't trained on public domain or licensed content? In which case, does that put us at a disadvantage in developing technological tools? If the US courts say this is infringement and it's willful, is that the death knell of all of the generative AI companies that we currently interact with? Question. So, a couple of questions to consider. Can licensing work on this scale? What do you think?
Suggested here before in a different session that metadata of the work can be used to track its use. So in that case, that would suggest it could work. That's good.
I'm going to push back.
Okay.
How many pieces of writing of yours have you tagged with metadata? How many Facebook posts, blog posts, images that you've put up? How much of that is tagged with metadata?
In all my images have metadata. The text doesn't.
Because when we're talking about this, and the reason the next question is who benefits the most when we talk about licensing, is because the data scraping, yes, they're scraping works of authorship, like books, but they're also scraping works of authorship like my Facebook posts from 2006. Like that is going into it. So who benefits the most from licensing? How many people's copyrights were infringed? How many people will actually see payout? Somebody recently said to me that it's going to be the collecting agencies that really see the big payout from generative AI licensing, if that's where we go. And again, what do we do if courts find there is infringement in the US?
I can't answer your question, but at any point in this talk about copyright and who benefits, is there any space or has there been any space in the discussion for the damage that can be done with this technology?
In the
Not
context
just
of,
who benefits, you know, just in turn, I think about university students no longer have to to really engage because they can just get it off ChatGPT.
So in the context of who's suffering in the copyright conversation, it's the people who are creating in that. So the impact to the wider community is not really the context of the copyright conversation. Well, it's not necessarily economic, it's also moral. So if my Facebook posts from 2006 go into training this, like they're being chopped and tokenized, and that's I have patrimony over those. That is my work of authorship. Not that they're brilliant or anything, but that is, my rights are being impacted there. But in terms of the broader conversation about whether AI is harmful or not, the ethics of training AI, that's sort of beyond the scope of copyright law. So we've talked about some of the input issues. There's also output issues in who owns what is spat out. And the US Copyright Office, again, the US is fairly active in this area, has issued some guidance. And their guidance basically says that generative AI created content is not protectable unless there is sufficient contribution of human creativity. So we must have some creative human component if it's more than an appreciable level of AI. And they've also talked about the fact that AI outputs are not predictable enough to be protected based on, I put a prompt in, I got something out. This came from a case over this piece of art known as A Recent Entrance to Paradise, created by Stephen Thaler using the creativity machine and AI he created. Now, when he tried to register this work, he tried to register it in the name of the AI rather than with himself as the author, and the Copyright Office refused registration on the grounds that this was not created by a human. Therefore, it's not protectable. But we also see cases like Zarya of the Dawn. Have you guys seen this comic book? So there's some right of publicity issues there, as that is clearly Zendaya, who is in that image. But our comic book author, Chris Castanova, wrote a comic book and then used Midjourney to generate images to integrate her text into. She then filed for registration with the Copyright Office. They granted it. And then she posted on social media that she had generated the art with Midjourney. And the Copyright Office found out and went back to her and said, we are now revoking your registration. You can only get registration for the words and arrangement. The images themselves are unprotectable. And the last is a piece of art that has won awards. The artist, Jason Allen, went through over 800 prompts, tweaking and refining to get to this image in Midjourney. He then exported it into Photoshop to create the image on the right. He filed for registration for this image and refused to declaim the parts that were created by AI. And so was refused registration. There are some problems with this notion of a de minimis amount of AI, or no, it's not de minimis, it's an appreciable amount of AI, resulting in a lack of copyright protection. And it comes from things like photographs. So there was actually a lot of brouhaha over whether photographs were protectable by copyright, whether they were sufficiently creative, because they merely record what's happening in front of us. And they were found to be creative. And this was actually the photograph that the very first case that went to the Supreme Court in the United States over. It was a photograph of Oscar Wilde. And it was found that the composition choices of the photographer were sufficient to make it protectable, to make it sufficiently creative. And so photographs have been protected ever since, including photographs like this, which is a beautiful photograph. However, how much human control went into it, given that it is a motion capture camera? So it was placed, but the subject matter of the photograph was not within the control of human beings. It was tripped by anything that moved nearby, but that is protected by copyright. Because because photographs are no longer being challenged as copyright protectable. However, the logic here and the logic here are not necessarily consistent. We also run into the problem of action painting. If we're saying that we must have predictability in outcome, what does that mean for the works of Jackson Pollock? Was it predictable what would come out? It's questionable. So the logic here is challenging. The justifications are challenging. This notion of what is human creativity, where do we find it? Just as a side note, there was somebody who trained a Gen AI model to generate action painting, and people can tell the difference between human-made and computer-generated action painting. Like there's something that we identify as human about the work of a human, which is kind of cool. All right, so I'd like to introduce you to Cheddar Charlie. And the story with Cheddar Charlie is my husband's a funny guy, and he has been playing with large language models, and he likes to give them the weirdest prompts he can think of. And so the prompt that he gave to ChatGPT was, speculate about the life of a sentient cheesecake who is a gangster living in 16th century England. He carries a pail of chutney and regularly drinks cups of 100-degree water. Now, this came back with a story, and I won't read the story to you, but it's great. And if you want access to it, I'm happy to share that story with you later. But the story entertained me so much that I decided to go to Midjourney and see if I could generate an image of Cheddar Charlie, the 16th century gangster, with his pail of chutney and his kettle of 100-degree water. I think he looks a lot like Winston Churchill. None of this is protectable because we used generative AI. The story's not protectable. The artwork's not protectable. And like, I am not a terrible artist, but I'm not that good. I couldn't do that with my own skill, but I did do that with my own skill. I went through many iterations to get to that. I then put it in Photoshop and modified it and edited it. But because the underlying image is still recognizably generative AI, I can't get it protected. Any of you can use and reuse Cheddar Charlie as you see fit. And actually, I welcome you to, if you want to use Cheddar Charlie, please feel free. And the reason I'm bringing this up is because at the heart of when we're thinking about what to do about AI outputs, there's two things that are happening here. It can democratize art. It can allow for new people to enter into the creative space who have been excluded. And my example of this, I actually have, is Blind Canvas. And Blind Canvas was an art project put on by a blind filmmaker who sat down and conducted interviews with people who were blind about their experience of blindness, and then generated prompts to put into a diffusion model art generator to create visual art expressing the experience of being blind. Never before would this have been possible, and I'm happy to pass this around. This is the art project. So it opens the visual art space to people who may have been excluded from it in the past. It has the potential to democratize art and creativity. But it also has the possibility of threatening art and creativity. And I told you I had a great example of good and a scary example. Behind me, you will see an image of Remy Michelle Clark. She is a voice actor. She's Irish. She actually was on that Fish Television Summit panel with me, talking about her experience of doing voice work that eventually was taken, fed through an AI generator, and is now in direct competition with her for voice work. Because the generative AI version of her voice is now out there. And that's not exactly copyright, because voice is not one of the things that we protect. Although there is legislation that's come out of Tennessee. Is that right? Yes, Tennessee, called the Elvis Act, adding voice to the right of publicity. So this may be sort of quasi-IP protectable stuff in the future, but that's the first of its kind legislation. So AI can be replacing people who work in the arts. AI can threaten people who work in the arts. So on the one hand, we have huge opportunity, and on the other, we have terrible, terrible risk. And so I guess at the end, my question is, do we want this? Do we want these tools? Because we do have the opportunity to say this is all infringing, that they need to go back to the drawing board and do it better and do it legally. We also are sort of questioning whether copyright is able to handle the challenge of AI, because when we're talking about licensing, the volume of material is monumental. It's epic. And much of that is not going to be sort of traditional authors or creators as we think of them. We also need to be thinking about how we draw the lines over what should be protected and what shouldn't, where those lines lie, what level of human creativity needs to be present. And the last and sort of more fundamental question that isn't really about AI at all is whether or not copyright still is, if it ever was, the right tool to protect and incentivize creative people. Because at the end of the day, I just want you to cast your mind around, how many creators do you know who actually make a living through their work, through copyright? For how many people does copyright actually, all the way back to the beginning, encourage Or for how many people is it not working and it's the intermediaries who really see the benefit? So is copyright the right tool at all? And so now we're going to go all the way back, and I'm going to do it this way rather than that way. No, wrong slide. There we go. I want to open that up. What do you guys think? I know I have taken you on an absolutely whirlwind tour of a lot of really heavy stuff, but what do you think?
Question about the first question aspect. If you want AI, is it really we here as like people in academia or like regular people who are kind of interacting with technology are to decide, or is it the legislatures in the end will decide on the future of technology? Because I'm not sure if we want it or not, it's going in a certain direction. I'm not sure if
Well, in a perfect world, we live in democracies. So what the legislatures do is subject to some of our control. In the real world, there's money, there's, but there is an opportunity to make some noise, particularly when it comes to this area where we're talking about it in the context of copyright. Do we want this? Do we want these models that have been already trained to continue to be the models that we are using? Or do we want them to, you're right, the technology is not going away, but the models that have been built on the basis of mass copyright infringement, potential mass copyright infringement, aren't necessarily the models that we need moving forward or want moving forward. And I'm not saying one way or the other here, I'm just posing the question.
What is the cap for them doing? They are so clearly infringed.
We find them out of existence.
But that's the democratic process. That is very.
Yes. There's the ability to bring lawsuits and lawsuits and lawsuits and lawsuits.
Is that this most straightforward?
I don't know.
Because that's just the intermediary.
Hey, I'm a lawyer. I'm I feel like I should put that out there. I am also a lawyer. I don't know, but if we find that these are infringing, fundamentally infringing, well, the US has some, well, there's also fair use, and it's just a very different doctrine. So it could be fair use if the court finds that the Google Books argument is, or the Google Books settlement, whatever, is the persuasive logic. It could be fair use, in which case there's not much we can do because, it's territorial and we can refuse to admit these products to the EU, but it's the internet, and what does that mean? And how would you prohibit it? And like, there's many questions. And you missed the beginning where I said, I have no answers, I just have questions.
Are the implications of it being properly teased out? That's sort of what it would be one of my questions. There's a sense in which AI is a novelty, right? There's another sense in which it's a legitimate tool that, if the data sets were compiled ethically, has great applications in things like special effects. But there's also an aspect where AI is being used to remove artists from the equation altogether. And there's no going back from that. Like, you cannot get a theatrical tech, say a lighting designer or something like that, in Ireland after COVID, because most people that worked in that industry ended up having to go elsewhere and do other jobs. So when things opened up again, there weren't any human beings to do those jobs. And at some point where AI has aged itself and the output is just constantly monstrous, because we're talking about a copy of a copy, ingesting another copy to produce a copy. And we turn around and go, we better get some human artists back into this. They're not going to be there. I mean, it's already impacting livelihoods there's a cartoonist I know in New York who in the space of a year, his work entirely dried up because people were bringing AI generator booths to events instead of like saying hiring a live artist. So the kind of those sort of implications, I don't know if they're actually being teased out properly at all.
Well, I will say in defense of the US Copyright Office, one of the things that has been a knock-on effect of its refusal to register anything that is sort of AI generated in this, basically the test is, if it looks like a human could have done it, then that's too much AI and we won't register. And the knock-on effect is there's a disincentivization for film industries, for the arts, because you can't protect anything that it generates. So if you have any interest in reusing and not being able to prohibit others from, that actually creates sort of a protective bubble around people working in the creative industries. Is it enough? I don't know. And did they sort of tease out all of the sort of knock-on implications? I don't think so, because as I said, there's sort of logical inconsistencies with other types of artwork. But I think that a lot of this is people flailing around trying to do something and not really sort of taking a comprehensive, cohesive approach. I mean, even the AI Act is, in terms of copyright, yes, they have to build in systems to respect the opt-out provisions of the CDSMD. That's kind of it.
Yeah.
And they have to list what they've used. That's not really thinking about, okay, what does this mean? I mean, even listing what they use, if we're talking about a petabyte of data, that document is going to be you're going to need machine learning to be able to access that document. And again, we sort of get into actually, there was a thing published recently that somebody has built a large language model to recognize large language models in academic publishing. So this sort of eating itself. I saw your hand and
I don't know, is this in any of these questions, but just what strikes, like, I'm a positive you talked about any of this, because I was trying to save my cat's life. But what you have, what creativity is sent, you have when you have an artist, to visualize, let's say a musician, because it's an easy one to do. The musician samples and listens or inputs
yes,
a whole selection of content,
yes,
and from that creates something. And so when you get creative intelligence with that intersection between the input and the human intelligence and creativity, but it strikes me when you put everything into the machine, what you get is stupidity.
yes.
And like the example, I gave an example of one that talks earlier. When we were talking about stereotypes of homelessness, and I just put in homeless person into an AI image generator, and I put it into a few, and they all get the same thing, which is a man in his 40s to 50s on the street with a beard, which is the stereotype of what homelessness is. But so what you get is the lowest common number. You get the stupid. It strikes me that and it's the same. Like I couldn't. I was trying to come up with struggling to put together an abstract for a conference. I had an idea. I couldn't. So I typed it into OpenAI. I said, give me 500 words on set design in the 1920s, and what it gave me was the most banal undergrad first year student essay thing. So it's the opposite of progress in a sense. It's regression to the mean.
Yes and no. I mean, so you may have missed my fabulous slide of Cheddar Charlie. This is a piece of art that I generated. He's a sentient cheesecake.
I think it might be in my phone.
Crafting prompts is hard. Like, it took me a long time to make this. And I think that that's, I sort of was talking about this in the context of whether or not there's sufficient human creativity in outputs. And in some cases, I mean, you type sentient cheesecake into DALL-E, and what you get is not this. I mean, you really have to give it a lot of detail. You have to be sort of working with it. But at the end of the day, it's a probability generator. So, it does give you what the most likely word following another word, following another word, following another word is. And the vast majority of what it consumes is not high quality academic papers. It's people who are not high quality academic authors. And so you do get sort of undergraduate level. And actually there's been research done that says it brings down the grades of the best students. It'll bring up the grades of the worst students, but it'll bring down the grades of the best students because it is the most probable answer rather than the right or the good. And it's not smart. It's dumb. It's just a probability generator. It's algorithmic language. So I've lost the plot of what it was I was trying to respond to.
I'm not sure what the question.
Okay, well, if we're both happy in the back there.
Oh, I was saying about like, the question of do we want AI, but I know we can't uninvent the technology, but it's not just visual arts or written work, it's stuff for music. It's stuff for two people are saying is it going to affect me? People are not going to go into music anymore. YouTube is peppered with AI songs and using other musicians' voices.
Yeah.
What could the issue be there?
I mean, once again, we sort of run into it is a opportunity and a risk. I mean, we had the first new Beatles song in a really long time. I don't know how many years, but a lot of years. And they used an AI to clean up a demo track of John Lennon's voice. So we had the very first new John Lennon recording. And that was done with AI, which is fabulous.
But we also had a new Beatles album, which was entirely AI generated, which was awful.
Yeah. So we have risks and opportunities.
But it's also, I think it comes back to the idea of a tool, like, what you're talking about there is machine learning as a tool.
Yeah, it is. And
it's not autonomous creative.
And I mean, a lot of the AI generated music is hot garbage. Like, that's just not good. But some of it, when it's used as a tool rather than as a replacement, it can be wonderful. It can be great. It's just, how do we draw these lines? How do we create these boundaries? And again, this sort of goes back to what the US Copyright Office is doing, which is saying that you can't protect it. If there is an appreciable amount of generative AI content, you cannot protect it. So why would anyone then do it? Because they can't benefit from it. They can't license it and ensure that there will be exclusivity to that license. On the other hand, where they've drawn the line is one that I think is a little bit iffy, inconsistent. Your hand was up.
Yeah, I was just wondering about the OpenAI opt-out provision. Is that something that's up and running? Like, is there a standard that they've created to opt out, or no?
No. This is part of, a lot of what the AI Act is going to do should help us there. But like having a standard opt-out provision, you could chase them down and ask. But again, it's a little bit of, they've already consumed most of what is on the internet, regardless of copyright. And there was a really good article in the New York Times yesterday that basically was saying, we're going to run out in the next 2 years. And we knew that this was copyright iffy, but we did it anyway because our need for data was so high that we were just willing to go forward. And that's true of Google, Microsoft, OpenAI, all of them. I don't know if you noticed that Google changed their terms of service for the Google suite of tools, that now anything that's publicly available on Google Drive is allowed to be scraped for their AI. So if you use Google Docs, if you use Google's suite of Office tools, and you're not making sure that that's private, they will scrape it. Yeah.
Yeah, so, like sometimes you see on the news that US Congress is like holding a hearing to regulate AI or Facebook or something. And you also see that they have no clue what those things are.
Yeah.
And both Republicans or Democrats, whatever. And they even like openly say that they don't have any clue, but yet they're still trying to regulate or see something. My question would be, are the people who have the power to analyze, evaluate this copyright thing, are they becoming like cognizant of AI practices? Like, are they redeveloping knowledge of it, or is it based on what they already know and they don't really care about it?
That is a complicated question. I don't think this is a US only problem. I think that legislators around the world interacting with technology run into the problem that people don't understand technology. And AI particularly is a real challenge. And the notion that AI is not intelligent, like that is surprisingly like controversial. When I say AI isn't intelligent, I have gotten so much pushback on that notion. So you have to sort of bear in mind the people who make it to the point where they get to make those decisions aren't necessarily the people who are on the ground interacting with the tools. That being said, I do think that the US Copyright Office is trying. I don't necessarily think they're right. And I think that in Europe and at the World Intellectual Property Organization, they're having meetings, they're trying to learn. It's just slow. So I don't know if that answers your question at all. I hope it does. Your hand was up.
It was the thing you mentioned before, like this increasing number of sites of data sets, right?
Yeah.
They're moving from one model to the other. It's like, it's not even double. It's like, I don't know how many times it's the size of the data set, but the need for bigger sizes, it comes from this precise need for intent prediction, right? Because their kind of claims that with each new model, they're predicting intent better than the previous one. And whenever the DALL-E is updated, they kind of remove the previous model, and as a user, you have to work with the latest one. But the thing is different with Midjourney. In Midjourney, you can use all their previous models and you can compare the same prompt in different models. And you can see, if you go to the first couple of models, the first, second, and the third one, you see the minimum number of data there gives a really interesting result, because they're not going for really precise intent prediction. And we talked about this, right? As the model progresses, kind of the interestingness of the output, I think, decreases at that point, because
It's sort of norms.
yeah, and it aims for a photorealistic, and this kind of, as you said, it aims for the average user, what they're expecting, and no failures, no accidents, nothing interesting happening there. I think maybe this kind of narrative has to change. Like, we have to look for generative AI. It's not something for precise intent prediction, but it's like creativity comes from the person, maybe 50%, and the other 50% from the algorithms.
There's a great Edward Abbey quote, "Growth for the sake of growth is the ideology of a cancer cell." And I think that there is a little bit of that happens with generative AI models where bigger is better, bigger is better, bigger is better, but we're not actually thinking about the use cases and the tools that we're trying to develop. We're just trying to make the biggest, fastest, best. But I think that you're right. We do sort of have this norming effect that, you know, it might be good for some use cases, but for others, like creative work, it maybe isn't.
I think this comes back to like the purpose of the Center for Creative Technologies, to round up the year, which is, you know, you shouldn't leave computer engineers in charge of this stuff. But genuinely, it should, like, because it echoes what happened with computer generated imagery when at first the computer engineers were charged, and what they try and do is make it perfect. And perfect reads wrong to us for a start. So then they started building in things like lens flares that don't exist in reality, but come from our experience of consuming media. So we're used to, if light passes in front of a lens, there's a flare, but it doesn't happen in real life. So you need to have those other voices in there, you know, to actually come back to those questions of value, really.
I absolutely agree. And this is actually something that we talk about in law a lot is, you know, because this sort of generative AI concept is something that we're talking about in the context of law and lawyering, and, you know, we're regulating this thing and we don't really understand it as policymakers, as lawyers, as people who are litigating, we don't understand it. And so, you know, I don't know if it's that we shouldn't leave the programmers in charge of everything, or if we should all become more literate and maybe a little bit more engaged in the coding side of things. And the creatives should be the creators. But I don't know, that's just.
I'm a creator, so, well, I think we're all creators really, but I'm comfortable saying I create. And what you're saying here is very interesting as well about like the kind of almost the 50% and what you talked about, like Pollock, they're not, that you see the generated one would be obvious versus the human. As like, I create abstract art and it's like, it's muscle memory and environment and a few other factors that come in. And it's like, so I suppose, is there going to be a tipping point, do you feel, where AI becomes more conscious of all of these things? I don't know if this is pushed out, but it's like at the moment it's scraping and gathering and creating that like perfect idea versus becoming more of its own consciousness. And then that then could be really beautiful, but would have to be respected in a different way. I know this is really pushing the boat out now, but like this is all really about the value and who gets the value of AI. It's like the ownership of the work, or is it the human, or is it the people who control AI that get valued, whatever that is, whether it's information, money. So are we really debating like AI's value or who gets the value of AI? This, like, I'm finding this really interesting from different perspectives, and I don't have any answers to anything, but just that's.
Are you talking about autonomy essentially?
Yeah, well, are we talking about that? It's like there's a sense of like if you were looking at this as community art and collective art, you'd say then, well, no one has ownership of someone's leading, but leading isn't more valuable than practicing. And it's like if nobody had ownership of this, it's a really beautiful tool that more people are coming into their own, even using, say, Midjourney. There's a very exciting part of that. And it's like, so, but then it's like, then we get kind of worried and go, but that's mine. And it's like, and it's kind of, like you said, it's the territory, it's like a land grab. It's like, who has to have ownership of it? I don't know if there's a specific, there's just a few thoughts going around there, but it's.
I mean, there's a lot there to unpack. God, I hope we don't get to autonomy, because that button pushing machine is going to realize how useless we are so fast. But, you know, yeah. I mean, there's a few out there that are a little bit terrifying. And now I've lost the plot. Train of thought left the station and I wasn't on it. I think that there is value in the question, you know, and thinking about where do we locate ownership, whether ownership is even the right tool and the right language, because we have really propertized copyright. You know, it now lasts life plus 70 years after you're dead. You have a fairly rigid monopolistic control over it. You license it to intermediaries who control it. You know what I mean? And so we have really land grabbed or enclosed this notion of creativity, and there are significant knock-on effects over and barriers to entry for people who want to come into the space. And even when I'm saying like the Copyright Office has said it's not protectable, so who's going to do it? Like even that thought is an extension of, well, we do this as a response to incentivization. And that actually is a maybe false premise, because most of the creators I know create because they are driven to create, not because they do hope someone will give them some money, because don't we all hope someone will give us some money to do the things we love? But they're not doing it because of copyright law. They're doing it because they're creative. So, you know, those questions are really, really valuable, and I don't have answers to them, but the conversation is worthwhile for sure.
Yeah, segue that, reading it like that fashion industry doesn't have those type of copyright protections, right?
The fashion industry has copyright protections in some things and not in others. So like the drawings that a designer puts together, those are protected by copyright, but the patterns, not so much. This is sort of the idea expression dichotomy. We don't allow you to protect facts and sort of the hard underlying concepts. This is why recipes are also not protected by copyright. The language used to express the recipe, yes, but the recipe itself, no.
Yeah, like I heard that's how fast fashion gets by and just
Yep.
like knocking off that thing that released yesterday. But the creator of the original, let's say, still like everybody knows that's the creator, still benefits. So it doesn't need copyright in all situations.
Well, this is where you sort of get the complementary right of trademark. And you will see that haute couture, luxury fashion, they are very, very rigorous over their trademark protections and really push the boundaries on sort of using trademark as a tool in those contexts. So you can take sort of things that look similar in fast fashion, but if you take something that is distinctively like Louis Vuitton, they're going to come after you for trademark rather than copyright, probably. Might come after you for both. And once again, I've lost, what was the question?
Like it was more on the like, does the artist need the copyright on that? Like people know you for the cheese gangster, you became famous.
God, I
You're
hope
still
so.
okay without the copyright in
Yeah.
here?
But I don't rely on Cheddar Charlie, the cheesy gangster, for my livelihood. I'm not someone who's a visual artist in New York trying to make a living doing graphic design. So, you know, if I was, I would rely more heavily on copyright because my livelihood depends on licensing those things.
But if you register for trademark and you're licensing, you're licensing to a cheese company, and then you can be protected.
Sure.
And get money.
Absolutely. And it lasts forever, trademark. So, you know, there's, yeah. I mean, there's always sort of other avenues. And at the end of the day, I mean, this last question is the one that I think is the most important question of all, is whether or not this is actually the right tool to, as we move into the future, as traditional art is threatened, but also given the opportunity of generative AI, is it the right tool? I saw your hand, yeah.
Yeah,
I'm coming at from the library perspective on with heritage collections and digitization. So we have digital collections fall under heritage collections, and we have many of our digitized or digital collections available. Open, we have that kind of policy and approach to be as open and accessible as possible with our digital collections, and we'll be selective about what we choose based on donor agreements or copyright. And so online we have CC with BY, NCND,
Mhm.
no copies of
Yep.
derivatives, but I'm just thinking that it's utterly pointless, isn't it? Because it's just the truth, it's been great, just the internet things, are we projecting our donors and our, you know, kind of.
Probably not.
Agreements. Yeah.
There's actually a really interesting article over whether Creative Commons has a place in the future with generative AI, whether it is actually a tool that works anymore. And, you know, I mean, yes, you are, because you are abiding by the letter of the law, but they didn't. So,
Yeah.
you know, this is challenging. I saw another hand over here.
When you're just saying that the fashion is really interesting, it's like if you get a picture of like a fashion designer's dress and then put it into like Amazon image search, and then you can find that from different kind of wholesalers because they're being replicated. And it's like, and I suppose that's the mix of AI and real world. So like they're just taking the designs where they're being made in factories and remaking them. And I think it's happening so fast, like AI, that we're not going to be able to spend all our time trying to catch. But I don't know, as an artist, I feel that, but maybe with other people who work with me, but it's going to be very hard to keep up with the speed that everything is kind of operating. And the fashion ones are really interesting perspective because you can see it. If you put in an image of one dress you like, you might find 3 makers of it.
What's really interesting about that is frequently what they've done is reproduced an image of the of that piece of clothing, and they will manufacture it when they get orders. So like, it's not even that they have a stock of those dresses available, it's that they've taken an image of it and then they will manufacture something that sort of, maybe this is why when you order clothes off of Wish or Temu, you know, a lot of the time it won't end up looking like the thing in the picture because it's just somebody working in a factory trying to get it done as quickly as possible. But you know, it's really hard to keep on top of it and to chase it, and particularly because all IP is sort of, you police it. You know, you're in charge of policing it, you're in charge of chasing it. And so, you know, in a world where you've got so many people doing so many things, and this actually sort of ties back to the volume of input issue and who's really going to benefit if we require licensing. You know, this is, you know, I could go backwards and tag everything I've ever put on the internet. I actually don't know if I could. I tried to get onto my MySpace page the other day. I can't get into my, like, and I had a band, there's band photos up there. My band still is on MySpace. I can't get on and access any of it. And the music's up there even, but like, you know, chasing it to try and get that sort of capture of this is mine. No.
Copyright law is, it's all civil law, right?
Yeah.
So that's the thing, it's like, they're hedging, that there's no possible way they're gonna be pursued by the rights holders, who range from one person to small organizations to.
I mean, this is why I was sort of featuring the New York Times, because they actually do have resources that are substantial enough that they, you know, can follow this through. Although, you know, in this, let's see if I can get back to the list of cases, and now I've lost my mouse. Let's do it this way. There are, so the Authors Guild are fairly substantial and litigious, and may be able to follow it through. There's a few where they're sort of organizations of people or cases that have been consolidated. So for instance, the Michael Chabon, the Kedry and Sarah Silverman cases have all been consolidated, and there's a fair bit of resources behind those names.
And that's like a class action sort of thing.
It's not a class action, they're bringing it in their own right.
Right.
But if they then succeed, then there's the ability to sort of, well, they succeeded. I now have a strong precedent, I can bring the case.
So there's no sort of class action in European law as such, is there?
But the European Union could bring suit.
Yeah.
I mean, that is something that could happen. I'm not sure under what law, but you know, this is part of the problem is this all developed sort of in violation of copyright, maybe, or maybe not. And the territoriality of copyright makes that a much harder judgment call to make. Because if everybody's based in the US and it's just us over here using it, and the US says it's okay, then they had lawful access. They actually fall into that exception under the copyright digital single market for text and data mining, if they had lawful access, which if it's all fair use, they did. So, you know, it's really challenging. It's really, really challenging. Yeah.
Are you excited by all of this?
Absolutely. Can't you tell?
Yeah, but it's just like, it is interesting, like, and it's like, there's so much fear around that, and especially for creators who are trying to make a living and all of that's like definitely a real aspect to it, but it's like, but does it outweigh that? Is the excitement bigger than that in terms of what's possible? And just like from your perspective.
I'm excited about the question of it. And at the end of the day, if you ever, you know, want to pick my brain about copyright, I think copyright doesn't do what it's supposed to do and should probably be something else. I think that we need to be thinking about alternative ways to support creatives, because at the end of the day, the people who make money off of copyright are not the artists, they're not the authors, they're not the creators, it's the intermediaries. And so, you know, I don't think copyright is fit for purpose. And so I see it as a moment of like, oh, what can we do? Where can we put pressure?
And the question occurs to me, like, why don't we go to an AI image generator and say, create me a picture of a lily pond in the style of Monet and then hang it on our wall? Or why don't we go to, you know, ChatGPT and say, you know, write me another chapter in the Harry Potter series and then read it? Because, like, if we do that, I don't think we do it in the way that we actually hang a Monet on the wall or actually read a book. Because I think so. It goes back like what you were saying at the start, like there was a legal change. Bound up with that legal change was a whole concept of authorship.
Yes.
That is so ingrained now, and that has all these other, you know, really problematic notions underpinning it around creativity, and it's frequently gendered, and it's all sorts of things that, you know, has been pulled apart in the arts and humanities. But those concepts, that's really resonant, that idea. You know, so we still, so that, you know, there is a possibility that this new technological landscape and the legal landscape that comes from that will subsequently transform our understandings of authorship in the same way that did. And we'll just think about all this very differently.
I hope so. I'd like, at the end of the day, this is where I think we should be going, is taking this and looking at it as a tool and thinking about how we can change policy to actually do the thing that we want to do, which is support humans. And, you know, that is, at the end of the day, I mean, that the notion of authorship is built around and has been used very strategically since its inception. Like, it was the publishers who pushed the Statute of Anne. It was not individual authors advocating for the protection of their authorship. It was the publishers trying to get that monopoly back. But the language has been used, and the language continues to be used to justify the sort of status quo of copyright. And we now have this moment of everything being so uncertain that, you know, we're standing on a precipice. So maybe we just push it a little, just a little.
Can I suggest that's a wonderful place? I'd just like to say a big thanks to.
I will say, if you want to reach out to me, if you want to talk about copyright law or video games or access to justice for people working in the arts, I'm happy to have chats. This is my email address. I'm also on the LinkedIn and the app formerly known as, which I will not say its name, I'm at Let's Open Culture. So that's ways to get in touch with me if you want to. And thank you all so much. This was such an interesting conversation. Yes, I need to add alt text to make them accessible. So I haven't given them to anyone yet, but I'm planning on doing that when I get back. So yes. They're absolutely
Just while
fine.
we're thanking people, thanks to Dave Kelly who did all the organizing.
Yeah.
As well.